Thank you, Mr. Chairman. Good afternoon. Mr. Rosenstein, can we agree that there's a difference between interfering with an election and actually changing the outcome of an election?
That's not an issue within my jurisdiction, Senator. If somebody interferes, it would be potentially a crime, whether it has an impact on the outcome or not. My answer is yes, there is certainly a difference.
Well, let's suppose that you're running for office and a super PAC runs ads criticizing you. The super PAC would be interfering legally in your election, but those ads may not impact the outcome of your election. Do you see the distinction I'm trying to make?
I do, and I apologize because I assumed that by interfere you meant unlawfully interfered. If somebody interferes lawfully, that would not be a law enforcement issue. They have a First Amendment right to do that.
Well, you can lawfully and unlawfully interfere.
If that's your definition of interfere, yes, sir.
Do you believe that Russia interfered with our elections in November?
Well, as I indicated in response to Senator Klobuchar, my understanding is that's the conclusion of the intelligence community. That's my only basis of knowledge, Senator, and so I have no reason to doubt that.
Can we agree that Russia has interfered in past elections in America?
I do not know the answer to that, Senator.
Okay. Have you ever heard of a group called Service A, which is the active measures branch of the first chief directorate of the KGB?
I do not recall ever hearing of that group.
Well, that's who did it. Are you aware that in 1968, Service A attempted to head off the election of Richard Nixon? The Kremlin offered to subsidize the campaign of his rivals. Are you aware of that?
Respecting one of your colleagues' earlier comments, I think I may have heard of Service A in newspaper stories about this, but that would be my only basis of knowledge.
Okay. Are you aware that in November of 1984, Service A tried to stop Ronald Reagan from being reelected?
I have no personal knowledge of that, no, Senator.
Okay. Are you aware that Service A planted stories in the United States that former President Kennedy was actually killed in a secret CIA plot?
I'm certainly aware that of some of the issues from the Cold War era, Senator, but I don't recall those specific details.
Okay. All right. Well, can we agree that Russia's interference, if any, in the election in November was not the first time it's tried to do that?
I simply don't have any personal knowledge of that, Senator. I accept your representation. If that's what the intelligence community concluded, I have no reason to doubt that, and I would be offended by it.
Okay. Well, let's get down to it. You're going to be in charge of this investigation. I want you to look me in the eye and tell me that you'll do it right, that you'll take it to its conclusion, and you'll report to the American people your results.
So, Senator, I would do every investigation within my authority right, and I believe that the 115,000 employees of the Department of Justice will support me in that, and we'll take it to the appropriate conclusion. The reporting aspect, Senator, I just don't know what that entails. When you're talking about national security information, there are a lot of agencies that have equities in that, and not just the Department of Justice. And I don't have experience with that. That's one of the areas where I would have to rely heavily on career officials. So I can assure you that as you know, I highly value our responsibility to inform the American people to the extent we can. So that's sort of my default position. If we have a lawful basis and it's appropriate for us to provide public information, I think it reassures the public when they know what we've done and why we've done it. So that would certainly be my preference.
Well, let me rephrase the question. Will you be willing to do what I just asked within the parameters of national security?
Within the parameters of national security and the law, yes, sir.
Okay. I happen to believe that a U.S. attorney is the most powerful position in American government. I guess maybe being president is more powerful, but
I hope so.
Well, it's an enormous amount of power. I mean, a U.S. attorney's job is to protect the American people. But at the same time, a U.S. attorney can ruin somebody's life. Are you comfortable with the checks and balances on the decisions that our U.S. attorneys make?
Yes, sir, I am. And I referred earlier to Robert Jackson's speech in the Great Hall of the Justice Department in 1940, and that's exactly the issue that he addressed. And I do agree with you that we do have significant power. Our assistant U.S. attorneys have significant power, and it's critical that they exercise that power responsibly.
Okay. Ms. Brand, let me ask you a question. I'd like you to talk to me about you've had some experience in this area, about your personal philosophy on the intersection of national security and privacy.
Well, thank you, Senator Kennedy. That is a really important, critically important question that I have spent quite a bit of time thinking about over the last several years. I think it's hard to talk about it in the abstract, of course. Anytime the government is going to undertake, for example, a surveillance program in the national security context, it's critical for them to do within the bounds of law, but not just within the bounds of law, also within the bounds of what is appropriate from a policy perspective in terms of protecting privacy interests. I think it's possible to account for both interests in every case, but where that line is, it depends on the circumstances.
Okay. Well, doesn't the power of government scare you a little bit in terms of your privacy rights? Just you as a citizen.
I would say the power of government, I don't know if it scares me, but I view the power of the federal government to be considerable and potentially concerning in virtually every area, which is why it's important to have checks and balances, legal requirements, and frankly, oversight.
Do you
area of
believe
government.
we have the proper checks and balances right now?
Well, again, Senator, that depends on the circumstances. I think in many areas, yes. Whether they always work correctly is another question, but I think the structure works well in the areas that I'm familiar with.
Okay. I want to thank you both for your willingness to serve.
Thank you, sir.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Congratulations to you both on your nominations. I'm going to ask Ms. Brand a question, and Mr. Rosenstein, you're free to space out on this one. Well, no, I just wanted to give him a moment to pause. Ms. Brand, can you comment on President Trump's claim about President Obama tapping his phones? Can a sitting president just order a wiretap or some other form of electronic surveillance? Is that how it's done?
Well, Senator, I can't comment on the comments because
I'm just answer. Could you just answer my question? Is that how it's done? Can the president just order a wiretap?
Well, under FISA, Senator, a court order is required, but I don't know any of the facts that underlie this question in this current debate, so I'm reluctant to speculate on a hypothetical beyond that.
Okay, well, he has to get a FISA order, I believe, and I suppose if he were a cat burglar and went through the air conditioning ducts, he could have done it himself. Mr. Rosenstein, exactly 8 weeks ago, this committee held a confirmation hearing for the Attorney General, my former colleague Jeff Sessions. Now, Attorney General Sessions and I have very different views about a lot of things, but the purpose of a confirmation hearing is not to resolve differences of opinion on policy. The purpose of a confirmation hearing is to allow the American people to decide for themselves through our exchanges here in the committee whether the nominee is qualified to serve. But in order for the hearing to truly serve that purpose, nominees must answer questions honestly. That's why they swear an oath. But 8 weeks ago, my question was not answered honestly. I asked then Senator Sessions the following question: if there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? I didn't ask who had communicated with the Russian government. I asked how the man positioned to become the nation's top law enforcement individual, a man who had served as chairman of the Trump campaign's National Security Advisory Committee, would conduct himself if circumstances required that the Department of Justice investigate members of that same campaign. Here's what then Senator Sessions said, and I quote, "Senator Franken, I'm not aware of any of those activities. I have been called a surrogate at a time or two in that campaign, and I did not have communications with the Russians." Let me repeat that. I did not have communications with the Russians. As we all know now, that wasn't true. Attorney General Sessions met at least twice with the Russian ambassador in 2016, once in July, an event during the Republican National Convention, and once in September in a private meeting in his Senate office. But Attorney General Sessions did not acknowledge the fact that his testimony misrepresented the truth until the Washington Post published an article exposing his meetings with the Russian ambassador. In the 7 weeks between his appearance before this committee and the publication of that article, Attorney General Sessions had ample opportunity to come clean and correct the record, but that's not what he did. So after an embarrassing story in the Post describing undisclosed meeting with the very same Russian official whose communications forced the president's national security advisor to resign, Attorney General Sessions hastily called a press conference and announced that he would recuse himself from overseeing any Justice Department investigation into Russian interference with the election. So, Mr. Rosenstein, now that the Attorney General has recused himself, it's your turn to answer my question, the very same question. Again, here is the question I asked then Senator Sessions, and that I would like you to answer now. If there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do?
If there is predication to believe that such a communication was in violation of federal law, Senator, I would ensure an appropriate investigation.
Now, Mr. Rosenstein, do you understand that you have an ongoing obligation to update your testimony and correct any inaccuracies or mistakes that you discover after you leave the hearing today?
You're making me very self-conscious, Senator, but yes, I believe I do. I'm trying to be as careful as I can.
Good. I must have just taken it for granted that witnesses understood their obligation to correct inaccuracies in their testimony, but evidently that obligation was not known to Attorney General Sessions. Yesterday, 4 days after the press conference at which he announced his recusal, and 55 days after his hearing, Attorney General Sessions finally wrote to the committee to update his testimony. In that updated testimony, the Attorney General references a letter written by this committee on March 3rd. Attorney General Sessions said, and I quote, "The letter asks why I did not supplement the record to note any contact with the Russian ambassador before its disclosure. Having considered my answer responsive, and no one having suggested otherwise, there was no need for a supplemented answer." So it would seem that in the Attorney General's view, unless this committee has reason to believe that a witness provided false testimony, or unless this committee suggests that a witness's answer is grossly misleading or unresponsive, that witness is relieved of his or her sworn duty to tell the truth, the whole truth, and nothing but the truth. But I don't think that's how it works. And in light of Attorney General Sessions' failure to recognize his obligation to this body, I thought it was important for me to make sure that you clearly understand this obligation. And you do understand this obligation, right?
I believe I do, Senator.
Okay. I think Senator Sessions should come back. I think he owes it to this committee to come back and to explain himself. Because he also says in his letter, may I just... I will not, this will be very short. He says, let's see, I did not mention communications I had with the Russian ambassador over the years because the question did not ask about them. I asked him what he would do as Attorney General if it was true that members of the campaign had met with the Russians. So he says, I did not mention communications I had with the Russian ambassador over the years because the question did not ask about them. He answered a question I didn't ask. And for him to put this in his letter as a response is insulting. And he should come back and explain himself, Mr. Chairman. I think he owes that to us. Because this appears to me like he was, and I've bent over backward, not to say that he lied. He needs to come back. I've bent over backward. I have given him the benefit of the doubt, but he has to come back.
Mr. Chairman, may I, sorry, may I just make one clarification, and I apologize, but Senator Franken's comments, I think, make it important for me to make this point. That is that I want to make sure I didn't misspeak earlier when I was asked about whether or not I would announce that an investigation was ending regarding Russia. I want to make sure you're all clear on this, that I do not know if there is an investigation. I don't know anything but what I've read in the newspapers at this point.
Well, I actually find it very disturbing that you did not read the declassified report on Russia's activities during the election. I find that very, very disturbing.
I read the newspaper story. I'm very, very sorry to hear that, Senator.
I would like to comment on what Senator Franken just said. And I don't expect Senator Franken to act like I would towards our witnesses, but as I remember Senator Franken asking his question of Senator Sessions, he referred to something that there had just been something come on CNN that obviously, and Franken said that Senator Sessions wouldn't know what it was, and he was going to take that into consideration, that it would have been all right for you to ask your question, and you probably should have given him a chance to get the information you had and reflect on it and give an answer in writing. Now, the way I tend to, and both of you know that I said this to you when you were in the privacy of my office. If I was going to ask you a gotcha question, I was going to tell you about it ahead of time. And I consider what Senator Franken asked Sessions at that late moment that story just come out as a gotcha question. And
it was not a gotcha question, sir.
It was, from the standpoint that he didn't know what you were asking about.
But I said that as I was asking the question. I said you haven't heard this, and I don't expect that you have heard it.
Senator, tell us.
Look at the tape, Mr. Chairman,
Thank you,
please.
Mr. Chair. Congratulations to both of you for being here and to your families. A couple of questions, very quick.